Jody mentioned, I'll be updating you on Santa Clara County's current status when it comes to evictions. Like she said, there are some counties and cities that still have a moratorium. I know Alameda County still has one, and it just depends where you are. But I think for today, we're going to talk about Santa Clara County. So first, I'm going to share my screen for most of the class so you can get a visual on what's going on. So first, let me go to, there we go. All right, so I think this is helpful just so as I go through these things, a couple of the items are fact intensive or code section intensive. So I think it's relevant to see it on the screen in addition to me talking about it, because if you want to take notes about a specific code section, something like that, I think it would be helpful. And I think you'll see why once we get going, just because the requirements are so specific, but we'll do an overview when we get there. So first, a general topic list of what I'll go over is the COVID-19 rental debt, what that is, what it means, what you can do, rent relief and pleading requirements, and rental protections and just cause in Santa Clara County. So these are the three primary topics that come up right now that the moratorium has ended and a lot of the protections regarding non-payment of rent have concluded. So we'll go over that. So first, COVID-19 rental debt. AB 832, and you've probably seen my talks before, and as you likely know, there's been several bills. There's been Senate Bill 91, there was AB 1482, AB 3088. There have been a ton of bills that have been passed over time over the last 2 years or so that have been meant to protect tenants, but most recently was AB 832, and that took effect on June 28th of this year. And what it did was it expanded and extended tenant protections through September 30th. And I know that was a big date and that has come and gone, but we'll break down what that date meant and what you can do now and what you have to do to seek rent that was owed before that time and the tenant didn't pay. But for purposes of this talk, quote unquote, COVID rental debt is defined as rent owed from March 1st, 2020 through September 30th, 2021. So if rent was unpaid for that time period, it's called COVID-19 rental debt. And so that's just important to know, because when you go and to file to evict or file to collect in small claims, it's important to know what time period you're in, because that changes the requirements, of course. Another big thing that AB 832 did was it altered filing requirements, and I'll go over those extensively. But that changed the forms that you have to use, the documents you have to provide, declarations, that type of thing, just to file the eviction. So I will walk you through that process. But big things to avoid when it comes to COVID-19 rental debt that I wanted to go over just before we get started. Number one, you cannot collect late fees for this rent. Typically you can. So say if you were to file to evict on this rent, you would include in your complaint, not in the 3-day notice or 15-day notice for that period, late fees. But what AB 832 says is that you cannot collect late fees for that rental period. Also, you can't penalize tenants for COVID-19 rental debt. And what do I mean by that? I wrote penalize because what the bill actually said was you can't increase the rent since they didn't pay during the COVID rental debt period. You can't now charge them increased deposit. Basically what it means is that you cannot disadvantage a tenant based on their failure to pay rent from March 1st, 2020 through September 30th, 2021. Another example that I've seen is that you can't choose to not rent to a tenant based on COVID-19 rental debt. So if a tenant applies for your unit and you find out that they had a history of missing rent payments during this time, you can't deny them as a tenant for that basis. You can, of course, deny them for other reasons. You actually don't really need to state a reason, but just make sure that you don't deny their application based on that failure to pay rent or some issues with COVID-19 rental debt. That's very important. And then third, you can't sell or assign the debt until November 1st, yesterday. So at this point, if you've met the other requirements, you can sell or assign that rent. There's one important thing that you cannot do when it comes to that, though, is you can't sell or assign the rent if rent relief is available. And I'll walk through rent relief. But if you could otherwise get rent relief from the state or federal government for that unpaid rent, technically you cannot sell or assign it. So that's just some things to note before we get too far into the weeds on this. Next, COVID-19 rental debt again. Requirements to avoid eviction if you're the tenant for this rent. Number one, they have to submit a declaration to the landlord that they've experienced COVID-19 financial distress, and that's why they didn't pay the rent. That's step one. Number two, they had to have paid 25% of the rent owed by September 30th. And so if they didn't do that, technically they're not protected. And that was for rent owed from September 1st, 2020 through September 30th, 2021. So if you imagine, say, a unit in Santa Clara County, $3,000 worth of rent times 11 or 12 months, that's $33,000 or more. They had to have paid 25% of that. So a lot of landlords that I represent and property managers, they had tenants that number one, they submitted a declaration, but September 30th came and went, and they didn't receive 25% of the rent because that's a big sum of money to come up with. So that was step two for tenants to avoid eviction. So if they haven't paid 25% of the rent, you can start the process, but there's other things that you have to do we'll talk about. But those are two requirements of the tenant to avoid eviction for that COVID-19 rental debt. Now, if the tenant does perform those two tasks, the rent debt converts to a consumer debt. And so at this point, as of October 1, going through November 1st, they made the new deadline November 1. As of November 1, you could file in small claims court. So you're not completely out of luck on that rent. And also up until 2025, you can file in small claims court with no jurisdictional limit. And what do I mean by that? That means that there isn't a $10,000 cap. So that's a big one. Like I mentioned, if the rent is $3,000, $4,000, or $5,000 a month, and they didn't pay 10 months worth or whatever the case may be, you could be looking at a huge debt owed, and you can collect that in small claims no matter the amount. Again, that starts a bigger discussion about, even if you go to small claims and get your judgment against the tenant, really what this comes down to ultimately is collecting. And if you've ever dealt with a tenant that hasn't paid or gotten a judgment against the tenant, you'll know that they are notoriously hard to collect from. The judgment is really just a piece of paper, not to discredit, the court services or judgment itself, but the real work comes in collecting. And a lot of tenants, they rent from a landlord because they don't own property, they don't have assets that you can otherwise lien. And so it is an uphill battle, even though the bill extended what you can collect in small claims. Getting the money in your hands is a whole nother story. And it actually bolsters my convincing of clients, or my argument to clients, that they should apply for rent relief, because otherwise you probably won't ever see that rent. Tenants are just impossible to collect from, and the money is there. And I'll talk more about that. And it's actually required in most cases for you to apply. So it's really a no-brainer to me. And then, as I mentioned in the prior slide, you cannot sell or assign that debt until you apply for the rent relief. And so that's just another reason to do it, in my opinion. Next one, so the rent relief program, who qualifies? Any affected tenant household with income that's less than 80% of the median income for the area. And this doesn't just mean rent for the tenant, also other expenses, including utilities. I've seen in some cases things like groceries or basic expenses that are meant to carry the tenant through, whatever period they're in. For example, in Santa Clara County, I pulled the AMI for a household of 4, and that's actually $117,750. And so if you have 4 people in the household, I think that's a little bit of a low threshold if 4 people living in a unit are only making that total amount. I think, that isn't very much money and they would need the relief. But again, if you're working in the area, you probably make more than that, I would guess, with 4 people. And so it is a hard threshold to meet. But you need to apply anyways, especially if you're the landlord, because it's a prerequisite to evicting a tenant or collecting from a tenant in small claims court. Now, how to apply. And I will share my screen once again. I'm going to first stop sharing, go to a different. I want to show you the website that you use. And so this is a very, in my opinion, well-designed website, considering, it's a government website, but it's housing.ca.gov, and the title of it is Housing is Key. And this is the most important website if you do have a tenant that didn't pay rent during the COVID-19 rental debt period, because you have to apply in order to evict them. It's a prerequisite, which I'll talk about. But if you scroll down, they have a ton of information for landlords, for tenants, for community partners, but there's really so much information in here for you to review. But just not only that, there's also a really straightforward application process. And so you can click apply now and walk through the process. And they do a really good job of helping you walk through that and meet your prerequisite, and also potentially get some money in your pocket if you are owed rent. So that is a very good website to check out. And if you do want to file to evict, or if you want to have me help you, I'm going to send you here anyways, and to have you get the application started. So I'm going to go back to my slide deck in just a second. Okay. All right, so I showed you the website, super helpful, super easy to navigate. And they also make it so landlords or tenants can apply. So you don't have to wait for your tenant to initiate the process. You could do it yourself. And then what happens is you fill out the application as a landlord, and it asks for the tenant's information. It asks for their address, phone number, and email. And so once you're done, an email will be sent to the tenant, and they'll be prompted to complete the application to see if they qualify. Really, the heart of you getting the money, the heart of the problem is that the tenant has to qualify. They have to submit documentation, but they receive an email, and they do try to make it very easy for the tenant. But I'll talk about some issues later on. But that's the website. That's how you get started. And for Santa Clara County, they actually have approximately $21 million available for this rent relief. And so there is money out there and money available that's been designated for this county. So it's very important to check that out. Again, big issue for landlords. I think this is the biggest one that I've seen, and it's call it what you will, but a lot of tenants are not cooperating because they don't seem very motivated, because they don't see the money in their pocket. It doesn't go to the tenant first, it goes directly to the landlord. And if they know that the landlord is trying to evict them or otherwise wants them out, I think they have the mentality that, oh, why would I help my landlord out and give them money when they're just trying to kick me out anyways? And so it's a bit of a retaliation tactic by a tenant. They can easily just fail to cooperate. Again, that causes issues for them, because if they don't fill out the application, they don't cooperate, you can still file to evict them, and you can tell the court that, look, I've done my due diligence, I've tried to get the rent relief money, the tenant won't cooperate, this is my only option. The court will grant you permission to kick that tenant out. But it is an issue that I've seen come up, and it shows that while fundamentally we have a good process to get landlords paid, the hurdle of having tenants having to cooperate and apply and also qualify it does create a barrier to landlords getting money that they otherwise should be paid. And so I think it's a bit of an issue. I don't know how you solve it, but it's just something to keep in mind, that even if you do apply and you know your tenant qualifies, you know, maybe they're not working or whatever the case may be, if they just blow you off and don't submit the documentation, then you're not going to get that money. So that's the rent relief program in a nutshell. Now, going on further with the rent relief program and then pleading requirements that have been changed by AB 832. This is the biggest one. This is the biggest code section. If you're going to write anything down, is that 1179.11 of California Code of Civil Procedure. Again, landlords must first apply for rent relief. And this is what the code section says, just so you know what I'm looking at when you come to me, when I get ready to file your action, to see if you're prepared to file or if we're at that stage yet. The code section says on or after October 1 and before March 30th the next year, in an unlawful detainer pertaining to this COVID-19 rental debt, the landlord must, number one, submit a statement verifying that they've completed a rent relief application and 20 days have passed since submission. And you have to provide a copy of the application, which I think is the simplest way to verify that. It's not necessarily required, but to me, it seems like judges have accepted the application, you know, more favorably than the landlord just saying that they applied. Second, you have to verify that the application was either denied or the tenant didn't cooperate. So you either have to have a tenant that does not qualify for the rent relief after they provided documentation, or you have to show that the tenant didn't cooperate. And you get a statement from the state saying, yeah, after multiple attempts, we didn't hear from the tenant, or the tenant said no, whatever the case may be, you have to submit a further verification to the court that happened. And you actually can't get a judgment until you receive that. So it's another roadblock. But I think the biggest issue to me, and I think landlords are the most disappointed, and this is why you should jump on that application ASAP, is that you have to wait 20 days after you submit the application to file your eviction action. So you're looking at 3 weeks just to get in the door if you haven't submitted that application yet. And then even from there, you still have to wait a reasonable amount of time for the tenant to cooperate. So there's a bit of a timeline in place here that you should be aware of, and that it, you know, if you come to my office and you want to kick them out in a couple of weeks, I mean, it's not going to be good news for you if you haven't applied. So make sure you get on that and get the process started, and you document all of these things, because we will have to submit that to the court. And then it's important to note, and I attended a webinar with the Santa Clara County Bar Association where they actually had a judge who rules on the evictions presenting, and she made note that the court is trying to discourage evictions for the COVID-19 rental debt due to the rent relief that is available. And so they really want to see that you've tried to utilize that relief before you go and knock on the court's door trying to get their help. So they really don't want to kick people out for that unless they have to. And then again, this form is a big one. This is Form UD 101. This is a new requirement within the last couple months or so, but the newest form was actually released last month. They've been changing it, it seems like every couple of weeks. And so if you're going to file an eviction action, make sure you're checking the court website to make sure you have the latest form. I think that's one of the bigger items to keep track of. And I'll show you the form that is being used. Let's see. Just one second. All right. Okay, so to most of you, this form may just look like a typical court template form. And as I mentioned, this is the UD 101 form, and this is used all over California. This is a 5-page form that is required. A court will not give you a summons unless you include this in your packet. But really, as an attorney and someone that files these all the time, I actually go through this form, and I recommend you do too, and just read it. Just look at what it states, because if you go through a lot of it, they do telegraph what the requirements are without looking at the code section. So I usually go in reverse. I usually look at the forms, and then I check every code section that the form has, and then I check the bill. So I go in reverse to what the court would be accepting, the code section supporting that form, and then the bill itself to sort of double check what I'm submitting. But if you go through this, it does telegraph what the requirements are, and I think it'll explain it for you. And so if you're doing this process on your own, which is fine, it will talk about what forms should have been served and should have been filed. Things like, the unlawful detainer notice expired before March of last year, what those requirements are in the code section related to it. I'm giving you guys a bit of a nugget here with this form, but I think it's helpful if you did decide to try and do this on your own, that this is really a big place where you start. And it walks through even the 25% payment status. And so it'll ask you, did the tenant pay 25% by X and X date? And I just think it's super important to be aware of these forms, and to also just read them and do a little bit of homework if you are involved in this kind of situation frequently. So I thought that would be helpful. Let me go back to my slides. Okay. So that form is probably the most important form and the one that changes the most. So make sure you're up to date on that. Obviously, if you came to me, I would make sure you would have the correct form, but I think there's no reason to hide the ball. I wanted to show you that so you can get eyes on it. Okay, moving forward, non-payment. And so I think one of the bigger issues, and this is just a general understanding my experience with clients recently, is that these moratoriums lasted for so long and they just now ended September 30th. I think there's a belief with landlords and property managers that you can't evict people, or it's so difficult, or their tenants are so protected now. Well, I think that is a misnomer. And I think if a tenant has still not paid rent beginning October 1, you need to be proactive. You can actually serve notice, and if they don't pay the full amount of the rent, you can evict on that basis. And so if this has been an ongoing problem, you have to do the prerequisites I stated before for rent owed from September 30th and before. But if they're also not paying starting in October this year, you can be proactive on that and potentially get the tenant out faster, depending on what we strategize to do. And it's a bit of it is a strategy decision. So as I mentioned, if a tenant is behind on a combination of COVID-19 rental debt and present debt, there's different options that we can utilize. And so if you came to me and you told me this was going on, I'd probably have you serve notices for any and all rent that's owed dating back a year. Just for your information, you can only serve a notice to pay dating back 12 months. And so we would be able to go back through November of last year, unless I would need to check the dates. So I would have you serve notices for every month that wasn't paid, and the necessary COVID-19 rental debt forms and all that. And then depending on how the tenant reacts, I may advise you to just file on the October 2021 rent. And why would I recommend that is, number one, you don't have to do the rent relief application. You don't have to wait the 20 days. You don't have to try and give the tenant an opportunity to pay that 25%, even though that deadline is blown. It's a bit of a fast track. If they don't pay after the notice is served for October, then in my opinion, yeah, you would be in theory waiving some of that past rent. But if your main goal is to get the tenant out, then we would have to strategize on what doors are open and what's the quickest route. And sometimes that is what we have to do as landlords and property managers is we do have to be creative if depending on what your end goal is. And so that's just something that I've seen happening. I've seen people kind of sit on their hands a little bit just because they feel helpless and they haven't received rent in so long, and it's left a bad taste in a lot of landlords' mouths. So just something I wanted to talk about before I keep going. Okay, rental protections and just cause. Before I get into that, I will take a pause and I'm going to review some of the questions that came in so far. So someone asked, what does sell or assign mean? My understanding of that, Marlena, is that as a landlord or someone that technically has a right to the debt owed, you can assign that to someone else and they can have the rights to collect that. It's kind of like if you had a judgment against a party and you assign that to a collection agency and they had rights to file and act on your behalf, it's similar to that. But what the law says on that is that you technically can't do that until you do the rent relief program. So it may be a moot issue by the time you do decide to sell or assign it. Again, if you're interested in that, the functionality of it, then we can talk offline and I can get you lined up with someone that can help you with that. Okay, when applying for relief, can we include rent due after September 30th? And can we add future months due after we apply? Technically, the answer is no. They also go by the COVID-19 rental debt definition that I've described for rent owed from March 2020 through September 30th, 2021. And so technically you would be in that window. And that's why I talked about being proactive, is that you are owed that rent for after September 30th, you're owed the full amount. And so if the tenant is not paying that, then I'd recommend that you move on that simultaneously. Because the rent relief program technically only covers rental debt related to COVID-19. Now, depending if you're in a different county, that may change because there's been different states of emergency and they may alter their definition of COVID-19 rental debt. So just be wary of that. But for Santa Clara County, my understanding that the short answer is no. Is there a landlord income limit to apply for the rent relief? Victoria, my understanding is no. The primary basis for qualification is tenant qualification, or is tenant income threshold. It's not based on landlord income. I think what they do though, however, is they look at applications and they do give rent relief to people that need it the most. So I'm not sure, number one, if you have to submit income limits for a landlord, like stated somewhat differently. I don't think you have to tell the housing department how much you make as a landlord. I don't think that's a requirement, but if it was, and your tenant and another similar tenant had similar incomes, what I understand the state to do is look at who needs it more. So if the landlord's income is relevant, maybe they'd give it to a landlord that makes less than you. But my understanding is it's not relevant, but I'd have to check with the housing department on that to confirm. When can landlord raise rent again? We haven't raised the rent since March 2021. So that's a good question, Lisa, or you said March 2020. Okay, so what the law says on this really quickly is that you can raise the rent once per 12 months. And that's pretty much a universal California law, except for commercial tenancies, of course, but you get one increase technically per 12 months. And so what I tell my landlord clients is that you want to make that rent increase quality, right? You only get to do it once a year, so you want to make the most of it. So depending on what type of property it is, Lisa, would dictate how much you can raise it. So if you're protected by just cause, which is on my slide right now, you're technically capped at 5% plus the CPI. And that's the increase in the consumer price index. And Santa Clara County, it's usually been about 2 to 3%. So for a protected property, that's what I'll call it, you're capped at about 7 to 8% per 12 months. Now, if you're not protected by just cause, then you technically can raise it much more than that, but depending on the amount would dictate your notice requirement. So if it's under 10%, or I think 10% or under, I believe 30 days notice is permissible, but if it's 10% or higher, it's actually 90 days now. And I can help you with that. And with the rent notice and the increase, you want to make sure you do those forms correctly. But technically it's 12 months, and then the amount really depends on what kind of property you have. And I'd be happy to help you with that, Lisa. Okay, another question. If evicting on October 2021, rent, how quickly are courts moving and how long to get a tenant out? I will talk about that, but in my opinion, courts are somewhat back to normal, or as close as quote unquote back to normal as I've seen. They're processing things pretty quickly. We have e-filing. The sheriff, when I give them a judgment, they usually get out to the property in about 2 weeks or so. And so I am encouraged that things are moving and things are happening, especially in small claims court. That's extremely fast as well. So things are moving back to normal. And then the last question for now, I have a tenant and they haven't paid for the last 7 months. And they are on a month-to-month. Let's see, this one, the person's name is Lopez. If you want to message me offline, your question would take quite a while to answer, and I can help you with that because you talk about a 30-day notice and also a notice to pay. And so there's a lot to unpack there and things you need to consider. And so if you want to talk to me offline about that, I will type my email in the chat right now and I'd be happy to help you. Okay, so let's go back to my slide. All right, someone asked a question on this already, but we have rental protections and just cause in California. As you know, AB 1482 changed the game really for most properties. As I mentioned, most tenancies are covered in California for units 15 years or older. And again, as I mentioned, there's an annual rent cap for increases of 5% plus the CPI, and that's Civil Code section 1947.12. And also section 827 is your rent increase notice section. And so you want to review that if you do want to serve a rent increase notice yourself. 827 is where you live when it comes to increasing the rent. Again, another requirement for just cause is that it has to be a 12-month or more lease. If you have a tenant in the unit that has a 6-month lease, technically they're not protected by just cause. Again, there's exceptions to that, but for the most case, the answer is no. Again, as I talked about before, and as you've probably read a ton of places, just cause is broken up into 2 separate sections. We have at-fault causes and no-fault causes. And I caution, this is one of the biggest mistakes I see people make when it comes to at-fault evictions, is most require a 2-step noticing process. So it requires a 3-day notice to cure and a 3-day notice to quit. And I'll explain that in the next slide. I'll give an example of what I mean by that, because it's a little bit contradictory to common sense, in my opinion, and it's easy to mess up. And so I think it would be helpful for me to go over that. And then also no fault evictions. Tenant assistance is required unless tenant fails to cooperate. And so if you are evicting for what we call a no fault, like an owner move-in or a remodel, you do have to pay relocation assistance. So make sure that you're doing that if you're engaging in that kind of eviction. Okay, at fault cause example. I actually dealt with this one, so it's not something I made up. A tenant actually did this at the property. Scenario, tenant installed a swimming pool without landlord consent. And so that, as you can imagine, that was quite the meeting to have with my landlord client. And I was surprised, I was impressed that a tenant would take that on, but it is a breach of the lease nonetheless. And the tenant didn't have the necessary safety precautions, excuse me. There's a lot of requirements if you do have a pool, especially if you have a tenant. There's a safety act in California where you have to meet a certain number of requirements to have a pool, things like signage, You have to have fencing, an alarm, and I actually have experience in that. So if you do have a pool at your property or have a tenant that is moving in, make sure you do talk to a lawyer about that because you can get in a lot of trouble. But going back to the scenario.
Ashley, can I ask you a question? Because I'm just baffled why someone would think it would be okay to put a pool.
No problem. I need some water anyways.
Are we talking like an in-ground pool, or they like spent tens of thousands of dollars, or is this one of those like giant, like 20-foot plastic kind of pools?
So a lot of you are probably, spinning that in your head, the price tag of a pool, right? I mean, 50, 60K if it's a legit permitted pool.
Yeah.
No, actually what the tenant did, I guess he's a contractor or something like that. He dug a humongous hole in the backyard and he actually put a doughboy pool in the ground.
Oh my
God. It wasn't something my client wanted, and it wasn't something that it just seemed like it would be riddled with issues down the road, right? Of it, what if the lining in the doughboy pool, it's just a mess. And so, I don't know how much the tenant spent because I think they did do some of the work themselves, but I mean, a pool really, it just was, it was mind-boggling for sure. But I was tasked with handling this tenant, so to speak. And as most of you know, with car leases, this is the violation in paragraph 17. There's a very clear alterations clause, and it says that a tenant cannot make alterations to the property without landlord consent. And so that was what we moved on. It was the most logical notice process, and we thought that it would be all but impossible for the tenant to cure the notice. And so what you have to do in this situation is you have to serve a 3-day notice to cure, and be careful with these. That they're very specific on what kind of language they require, and they actually require you to be specific about what you want and what the breach is. And so we had to talk about, you need to remove the pool, you need to replace the dirt, all that, right? And then you have to wait the 3 days, and that only counts business days. And then once you're able to confirm that they didn't cure within the 3 days, you have to then serve a 3-day notice to quit. So, and why that's required, I don't really understand why. And it does kind of bug me a little bit, but it is a requirement in the code. And if you go to evict a tenant for this significant breach and you only served a 3-day notice to cure or quit, and you filed on that, the judge is going to tell you, tough luck, you have to start over. And so I just thought that was an important requirement to discuss because it's not really inherent and it's not obvious. So you have to do a 3-day notice to cure, and then you have to do a 3-day notice to quit. Now, this is if it's a curable breach. Not all breaches are curable. Things like if you found them selling drugs or doing something illegal, that only requires a 3-day notice to quit. But again, just be careful with those 3-day notices to cure because it is a 2-step process, as I've discussed. And then only if they fail to cure and they fail to vacate after the subsequent notice can you file to evict. Okay, local protections and no fault cause example. So as I mentioned, AB 832 gives preference to local protections. And so if there's something local that is more protective of tenants than the state protections, and local prevails, that's usually pretty standard with law, constitutional law, federal law. But for AB 832, that's also the case. And Mountain View and San Jose in particular, they have their own protections, and those must be honored before AB 832. So depending on where your property is, requirements may change. And additional noticing may be required. And in some cases, you have to notify the city of your notice or even the eviction. I believe for the city of San Jose, for certain rent increases and notices to evict, you have to file them with the city. It's a complicated process, but we're equipped to handle that. But just be careful that you're not ignoring that requirement just because AB 832 says what you have to do. No, you have to go deeper than that and look at your local protections as well. just like we talked about in the beginning, and Jody mentioned, places like Alameda County still have a moratorium in effect technically. And so AB 832 is technically irrelevant for the time being. So it's just important to check that out. Now, a no fault cause example, and I put / move out agreement because this is where landlords mess up on this. So where I mentioned rental assistance is required for no fault evictions. And what I mean by that is if you're evicting a tenant for something that's not their fault, like the owner needs to move in, you're doing a significant remodel based on a health and safety code violation, something like that, you have to technically pay them 1 month's rent unless local protections provide for more. But what I see happening is that a lot of times the tenant will say, oh, hey, I understand, you need to move in, A, B, C, and D, and they'll agree to a move out agreement where the landlord pays them. It's a cash for keys type deal. It's very common where you pay a tenant a set amount, and if they vacate on the date that they agree to, you pay them and you go on your separate ways. Now, the issue with that I saw in one case was when rental assistance required $7,000 to be paid to the tenant, but the tenant agreed to $5,000. It was a violation of the tenant protection laws. So long story short, the tenant cannot waive their rights under AB 832 or really any protections. And so just make sure, even if they're signing an agreement, if later on they get disgruntled or unhappy and they do want to move on you for violating their rights, they would be able to in that instance, even though you paid them. So just make sure that you are up to date on these types of things and not discrediting the tenant's rights, even if it's a voluntary move out. Okay, next, general outlook and court status. Someone asked this before. As I mentioned, things are starting to go back to normal, so to speak. Trials are being held and they're processing these actions pretty quickly like they used to do. From judgment to sheriff, lockout processing times have improved. I know there was a time back when these protections first went into effect where I remember I had to talk to the sheriff's department because they saw eviction moratorium and thought, shoot, I better not evict anybody because there's a moratorium. And so we actually had a client that got in touch with a city council member who had to teach the sheriff's department, the civil unit, what the moratorium means. And then that actually got them going again. So that was pretty cool to see. But I think there was a lot of confusion before about what was allowed and what wasn't. And the last thing the sheriff's department wanted to do was violate a bunch of tenants' rights. And so they really were at a standstill, but they are back up and running pretty much full steam. They have some staffing issues, but that's a whole other topic. Again, court forms change constantly, be very diligent. The judicial council forms, like I mentioned, that UD 101 form I showed you earlier in the presentation, that the version before that one was only about a month before that. So within a month it changed. I actually seen a complaint filed by an opposing party rejected due to that filing a stale form. And so it is easy to mess up, but make sure you're checking the court website. And then to plug my firm and what I provide is it is a good idea to seek legal counsel if you are planning to evict. And for all of the reasons that I mentioned before, as you can see, there's a ton of pitfalls. So if you are planning to get a tenant out, especially now, do seek out the help if you can't afford it. And if it's something that you need help on, if you don't really understand the laws, we'd be happy to help. And so now I will open it up to more questions. Let me see. I have one remaining one from Victoria. If the tenant is on a month-to-month lease and they've been there for about 10 years, they pay on time, and the seller wants to sell the house, it's a super common question, and the tenant doesn't move out. So for this one, Victoria, and if you want to respond to me live, I would need to know what kind of property this is, because in order to be protected by just cause, it has to be a very specific type of property. And then there's also forms that you have to serve to be exempt. It's a triplex. Okay, so yeah, you would almost always be protected by just cause in that situation. So yeah, the tough answer, Victoria, is that you would need just cause, and there's 12 causes, and I've given presentations on this before, and I can send you the causes if you want to review them with your client. You either have to have the tenant do something wrong, or the landlord has to have a no fault cause to get the tenant out. And that includes things like I mentioned a couple times, owner move-in, significant remodel, things like taking the property off the rental market, which wouldn't apply in this case because selling the property technically isn't that, because what the buyer would have to agree to, which they usually won't, is to not put the property on the rental market for anywhere from 2 to 3 years, depending on the Ellis Act. But really, you would have to find cause, or alternatively, Victoria, you could get the tenants to move by way of a cash for keys deal. So maybe there's a number out there that they would take to move out so your client can sell the property. But this is probably the biggest issue that landlords face right now, is trying to get tenants out, and they want to sell. They either want to move or they want to liquidate their assets, and they have tenants in there. And I saw something, and don't quote me on this, I seen an article where it said properties sell for at least 20% less when there's a tenant in the property compared to when it's vacant. So there is a lot of motivation to get the tenant out. And so it is a big issue. Yeah, I will send you those causes, Victoria. Let me make note of that. Send me, just type your email in the chat and I'll get that over to you. Does anyone else have any questions, or Jody, if you want to open it up for anyone else to speak, or whatever you want.
If anybody wants to, open it up or ask questions, you're more than welcome to. So if you'd like to raise your hand, I would say that it is super important to get an attorney to help you with certain things, because you want to make sure you're doing it right. The last thing you want is for that tenant to come after you. And there's a lot of groups out there that will help them do that. So just, protect yourself, protect your assets and things like that. And I don't know if you covered this, I was kind of in and out. Did you cover how back the courts are right now, or how long it's taking?
Yeah, I did cover that.
Okay.
And I think that that's a bit of there's some confusion going on with that. It's not as bad as people think. I think that there was this anticipation that come October 1, right, the gates open back up and we're just going to see this flooding of filings. But I think what the biggest issue is the requirement I talked about the rent relief program. And so if you are evicting for COVID-19 rental debt, you have to wait that 20 days before you file, after you fill out the application. So I think it maybe not intentionally, it's staggered filings. And so you have people that had already applied that are filing to evict, and then people that had not yet applied, they didn't know about the requirement, who are now having to wait 3 weeks. Maybe they're filing now, but I think that's a misconception. I think that in my opinion, it is back to normal for the most part.
Okay. There is a question. Is there a specific form to use for rent increases?
Yes, there is. And if you give me 2 seconds, I will get the CAR form label for you. Give me just 1 second. I just did a bunch of these, but I want to be sure. Hold on.
And it almost sounds like, I'm going to say the Bay Area specifically, but maybe the number of people that were behind on rent wasn't as many people as kind of we were led to think. Other parts of the country, I think it clearly is a huge issue for sure. But it sounds like here it's happening, but not as much as we thought it was.
Yeah, I mean, really, I think the benefit of our area is that we are focused area and a lot of people can work from home. And so what happened was when tenants were put on the spot to prove or sign a declaration under penalty of perjury that they had been affected by COVID-19 when it comes to their finances, some were a little bit wary to sign that, and maybe they never stopped working, right? Maybe everything as far as their job came, when it comes to that, it stayed normal. Again, that doesn't, I know there's a ton of people that were devastated by it. But in my opinion, really, since we're talking about residential right now, I think commercial took a bigger hit just because the businesses weren't getting traffic, they weren't getting people in, and I've actually seen more commercial tenants either close or be evicted more than residential ones. So
yeah, we signed a new lease for a commercial space. We own a small business, and I will say that they asked for a whole lot more financial information than they did 5 years ago. And I just explained to my husband, that's because they want to make sure that should something happen, we are stable.
Yeah, and in addition to that, if you're in the commercial realm now, I mean, it is a little bit of a tenant's market, and also in residential too. But just be careful, because you bring up an interesting point that while COVID did scar some landlords and make them skeptical about people not paying the rent, and fearful that maybe if another virus or something pops up and this all starts over again, they're going to have to go 12, 13, 14 months without rent. I've seen people ask some inappropriate questions, some questions that violate tenants' rights. You know, you have children, or do you plan to have children? Are you pregnant? You know, crazy stuff. And like I mentioned, a tenant installing a swimming pool, landlords do dumb stuff too. And I had a client that asked her potential tenant if she was pregnant, and I just said, hey, this is not, we're not going to do that, right?
Just like when you're hiring somebody for a job, like
yeah, same thing. So I think COVID did make people just more skeptical and more they want to make sure that they're paid. So it's a valid concern, but just be careful on what you're asking and really what information you're requiring.
Mm-hmm.
Question: tenant hasn't paid this year, so I'm guessing January 2021 through now. Okay, great question, Lisa. And so how this works and what the law says is that, well, technically, depending on when you applied, I think in some cases the rent relief covers the full amount, but don't quote me on that. But if you do accept the rent relief, you have to waive the remaining 25%. That's the trade-off, and you can never evict for that past due rent. So yeah, technically you have to waive it if you do accept the assistance. Again, one important thing to know though is that if the tenant pays 25% to avoid eviction and you don't qualify for rent relief, you can actually seek that other 75% in small claims court. It's a consumer debt, as I mentioned. So if the tenant signs a declaration and pays 25%, the other 75% isn't waived, it's not gone, you can go after it. It's just, it would be either a civil action or a small claims action, and it wouldn't be related to evicting them. It'd be like you're collecting on a breach of contract. So.
And those are more than $10,000 right now for small claims.
Yeah, it's unlimited, and that's for another, I think I said 2025, October 2025. So quite a while.
Does that have to be related to COVID, or is that just, that's a long time to go out, 4 years is a long time.
Yeah, so I asked that at the SCCBA presentation, and what happened, what they said is that there is a backlog with civil cases. So when I talk about eviction cases not being backlogged, that's relatively true. But if you go and file a civil action right now for, say, negligent misrepresentation or broker negligence, fiduciary duty, that type of case, yeah, you might not see a trial for 2 years. So what they didn't want because they didn't want people filing a civil action for past due rent over 10K, further clogging up the civil court. And small claims, if you file an action, you could probably file it and have a hearing date within a month and be done with it compared to 2 years. So, yeah. Let's see. Yeah, so Jim, you asked about the CPI. I think this is Diane's Jim. There is a specific website about where you're at and how to calculate that. It's typically from April of the prior year to the present, but I'll give that to Diane so you have it. Not a problem there, Jim. Lisa, so there's no rent relief starting October 2021. Technically, no. It's technically for the COVID-19 rental debt period. There are some exceptions depending on your locale about if you're, say, Alameda County, their emergency status ended September 30th, and what their moratorium says is that for 60 days after that, you can't evict a tenant. And so I would presume that if you applied for the rent relief for that kind of area, you can get assistance. But technically, no, Lisa, and that's why I mentioned you should be proactive with serving notices for after October, just because number one, you have a right to, but number two is that you're not going to receive the same protections from the housing.ca website and all of those different programs, either statewide or federal. Anybody else?
Do you have any other questions for Ashley while we've got her? Otherwise, I think I'd like to do a class with you on dumb stuff tenants do, like pools in the backyard. Like that one still baffles me.
Yeah, so I actually had another group of tenants, and this was related to employee housing, where a corporation rented a residential property and had workers stay there, maybe coming from way far away, and they'd work here for 3-4 days and then go home. My client had to go there for some electrical work, or whatever the case may be, and they had installed an additional bedroom without a permit. And so that was a significant one. That may be along the lines of something where you can serve notice that's not curable because it's damaged the property. The pool, yeah, but just so all of you know, a lot of the stuff is judgment based. And so if you come to me with a breach by a tenant, and statutorily you may be able to get them out without giving them the opportunity to cure, sometimes the better option is to go the safer route and say, look, we'll give you 3 days to fix this issue, even though I think this may be something I can evict without even letting them do anything. You have to put yourself in front of the judge, and will they say, well, this isn't really damaging the property, they added value, it was built correctly. And so everything I tell you is more in line with what the law says, but the practice of it is just based on my experience with judges, and they do give preference to tenants. And yeah, Jody, they do crazy and dumb stuff, and it's not as simple as it sounds. And you do have to, they give them every opportunity you can to let them fix it. Otherwise, you probably can't get them out.
Wow. Good
Yeah.
Lord.
You know, based on such a contract that they have extra people living in the property. Yes, especially for adults, you want to be careful for family discrimination on this. So you want to make sure you don't just serve notice without verifying who these people are. But there is the first paragraph of a car residential lease. It says occupants, and it says in there specifically who can occupy the property. And so if you can prove that they're not a guest, if you have a guest clause and that they're a permanent resident in there, that one's hard to prove. It's a hard one to evict on, Mary, just because you're not in the unit. It's hard to inspect. Usually if you give notice of an inspection based on that breach, they're not going to be there.
Clean it up.
Yeah, so that one's tough. My advice would be you serve notice to send a warning shot and put them on notice. And if you are able to prove that they're living there full on, then yeah, you can evict them technically. But like I said, I just said to Jody, it's more of a proof thing. It's more of a practice pointer. Are we going to be able to prove this at a trial and show that when we served notice they were breaching, and then after expiration, were they still breaching? You have to have some kind of evidence and proof, maybe neighbor declarations. It just, you really have to build that up.
Yeah.
Anybody else?
Nope. And we did record this. So
Great.
give me some time. I gotta get it over to our production guy, and then he's gonna take out the hi, how are yous and this part. And then we'll get it out to everybody. So give me later this week or very early next week, but we will get the recording out to everybody so that you can listen again and hear the name of all the forms. And I personally strongly recommend Ashley. She's awesome. Anybody at Brewer would do a great job. I highly recommend you have somebody help you with these things because it can get messy fast. So
yeah.
So thanks for everybody for being here. And again, give us some time to get the recording.